Constitutional Court has today ruled that a former Finance Minister, Pravin Gordhan, was wrong to try and institute a system where companies bidding for government contracts under certain conditions were disqualified if they did not meet black economic empowerment criteria. In other words, as I understand the media's summary of the judgment, the minister does not have the power to issue these regulations. One of the organizations that brought the main application, the business group Saka Lega, says this is the first time that any BEE legislation has been, as they call it, rolled back by a court judgment. Are they right to see it in that way? Thabo Masombuka is a senior legal and transformation consultant. He joins us now. Thabo, good afternoon to you. BEE law can be simple and it can be complex. This is a complex judgment. There's a minority opinion and a majority decision. It was very close in the Constitutional Court. It also seems to put different pieces of legislation against each other. So, in your view, what does the ruling actually mean?
Good afternoon, Stephen, and good afternoon to your viewers. You're correct, it was a close call. It was a close call, but only in respect of the technical aspects of the procedural segment of the ruling. You would recall that in law, for any policy framework, for any legislative instrument to pass the test of scrutiny, it must be substantively and procedurally correct. Just a bit of a background so that your viewers can understand. This all started when the Minister of Finance at the time, exercising his powers in terms of Section 2 and Section 5 of the Preferential Procurement Framework Act, issued what was then called the Procurement Regulations in 2017, which allowed organs of state to disqualify all bids which are not acceptable. So a bid can only be unacceptable when it does not meet the pre-qualification criteria, which now meant at the time that you had to have compliance with BEE, EME and QAE and all other lists that is listed there. Now, the reason why Agribusiness approached the court in the High Court was because they requested the minister at the time to extend the period of consultation. You'd recall that in terms of the Promotion of Access to Justice, Administrative Justice Act, a minister or any accounting authority can, issue a piece of legislation or a policy framework for input for 60 days, but the minister at the time had issued it for 30 days. So they successfully challenged the minister to say 30 days was not enough for consultation. Otherwise, you're not going to attract sufficient consultation. And the High Court then found in favor of the minister because it said there was an extension that was granted in favor of AfriForum and all other complaining bodies. So that's the background. So this matter went straight to the Supreme Court of Appeal, and the Supreme Court of Appeal agreed with Agribusiness and said, in fact, over and above the fact that the minister did not provide what is called sufficient period of consultation, the minister is not empowered in terms of the Act to issue such regulations. Now the Constitutional Court has agreed with the majority view of the Constitutional Court has agreed with the Supreme Court of Appeal that yes, the minister does not have the authority to issue such regulations, but who has? The organs of state. So in other words, this ruling does not say that BEE should not be a requirement. It doesn't say that empowerment should not be, local content should not be a requirement, but all it says is that the minister is not empowered to do what others can already do, which are the organs of state and the various departments. That's all, that's the long and short of this judgment.
So, Thabo, journalists use a different phrase, I think, to say what you say. We call it a technical judgment, by which I mean the aim that government wanted to achieve here. In other words, the aim, as I understand it, was to say that only companies that met BEE criteria could bid for certain contracts can actually do that. They can do that. It's just the way they went about it. The technicality is in the way they went about it. Is that right?
That's partly correct, but listen to what the SCA has said, Stephen. The SCA has said the invalidity aspect is suspended for 12 months. So what it actually means, the National Treasury or the Minister of Finance in its current form is provided an opportunity within 12 months to correct whatever administrative default that is picked up by the judgment in the Constitutional Court. So this judgment has simply said to the minister, you have one of three options. One option is to, correct the defect, the procedural defect that you, as the minister, as an executive authority, don't have to issue the guidelines, or introduce a bill that has an effect of replacing these regulations and take it back to Parliament, or thirdly, engage with the organs of state and give them the authority and tell them what to do if you feel that by these procurement regulations, they were not doing what they do. So what this effectively means, this judgment technically takes back the power from the minister to the organs of state. And it makes sense from a substantive transformation point of view, Stephen, because the various departments oversees different aspects, sectors of the economy. Agriculture, for instance, cannot have the same regulatory policy framework, procurement policy like maritime. So can ICT not have the same with health, for instance. So this judgment opportunistically present an opportunity for all procurement administrators in the various organs of state to now review their policy framework, issue it in accordance with what is suitable and make sense in their various sectors.
Okay. So I mean, the issue of black-based economic empowerment, it's very interesting from a legal point of view. Are you expecting some more legal challenges and rulings? I mean, there are people with a huge interest in challenging what government is trying to do. Are you expecting, and this, as you know, was very close, are you expecting more interesting judgments on this?
There has obviously been a systematic pushback of your broad-based economic transformation legislative framework in the country. But if you all look at it, it has not been on substantive basis. Even this judgment, for an example, even the legal counsel representing Agribusiness acknowledged that the Preferential Framework Act is based on Section 217 of the Constitution, and everyone accepts that Section 217 of the Constitution effectively ensures that when goods and contracts are issued on behalf of government, that must be done in a manner that is price efficient, that is effective, transparent, but more importantly, that takes into account historically designated sectors. So that Section 217 was well crafted, well thought. It provides sufficient ground upon which all other policies can find resonance, especially from an economic redress point of view. So if you look at the systematic pushback I spoke about on BEE and all other pieces of legislation, it has only been on technical and procedural ground. But in effect, no one has got the legal and the argumentative strength to be able to challenge the value imposed by the provisions of Section 2172 of the Constitution, to an extent that it says organs of state and any other public sector implementer of policy must take into account in their implementation of BEE or policy framework what is called economic redress for those historically disadvantaged. So I've made a few calls and I've responded to a few messages this morning who were worried that, but Thabo, what does it mean for BEE? Does it mean now BEE is going to be thrown out of the window? I said, no, this judgment doesn't mean that. This judgment simply means that if you do these pre-qualifications, do them correctly, but the organs of state, and not the minister, is now the custodian of the process of doing that.
Thabo Masombuka, I really appreciate the time and the explanation. Thank you. A senior legal and transformation consultant on that constitutional court decision made public today.